Good evening, everyone. Thank you for joining us for tonight's webinar on contemporary legal issues in screenwriting. My name is Vanessa Esperanza Quintero, and I'm the Educational Programs Coordinator for CLA's Los Angeles office. I'm looking forward to this evening's presentation. We are happy to welcome you all to CLA. For those of you who are not familiar with us, CLA is a statewide nonprofit organization serving the arts community by providing a number of legal and educational resources across the state. I would also like to take a quick moment and share about the benefits of purchasing a membership with CLA and encouraging you to consider joining CLA as a member. Membership with California Lawyers for the Arts, you save up to 50% on educational programs, save $15 on every referral fee, and enjoy discounts on our soon-to-be released video-on-demand library of workshops and MCLE programs. You will also have free access to recorded workshops in our foundational series, which will cover fundamental intellectual property topics. With your support, CLA continues to provide critically needed legal conflict resolution and educational programs for artists and arts organizations throughout California, while vigorously advocating for the intrinsic value of the arts. To share a bit more about our programs and services, I'd like to play a short video from our Executive Director, Alma Robinson.
Hello, my name is Alma Robinson, and I am the Executive Director of California Lawyers for the Arts. CLA is a statewide nonprofit organization that was founded in 1974 to serve artists and arts organizations of all disciplines with advocacy, as well as services that provide support with legal and business issues. With staffed offices in San Francisco, Berkeley, Sacramento, Los Angeles, and San Diego, we provide several core services. First, we provide legal counseling to specialized attorneys who provide assistance with a variety of intellectual property questions, as well as contract reviews and negotiations, and other important business issues. Depending on the client's financial status, legal assistance may be available on a pro bono or reduced fee basis. We also provide a specialized program that assists independent inventors and small startups with their patent applications. To help with situations involving disputes, we provide a range of alternative services, including negotiations counseling, mediation, and arbitration that can avoid the expense and hassle of going to court. Finally, we offer a full menu of educational programs that include workshops, symposia, and conferences on various legal topics for artists and arts organizations. Many of these programs are posted on our YouTube channel, and we encourage you to use these tools to educate yourself on the legal issues before you reach out for specialized assistance from our organization. Thank you for joining today's program, and please consider joining CLA on our website at www.calawyersforthearts.org so that we can continue to maintain our full range of services. Thank you.
I would like to go ahead and get us started with our workshop. Now I'd like to invite Tifanie Acosta, our speaker this evening, to join us on camera as I read a bit of an introduction. The founder and the managing partner at Entertainment Law Partners, PC, where she specializes in representing entertainment, corporate, and entrepreneur clients, as well as individual actors, performers, writers, authors, directors, executive producers, musicians, agents, PR agencies, managers, and producers in all aspects of the corporate business and entertainment industry. She received her undergraduate degree from the University of Colorado, Boulder, and her JD from Loyola Law School, Los Angeles. Welcome, Tifanie.
Thank you. I'm Tifanie. I do want to quickly give some credit to my law clerk's son. She did a great job on this, and I really appreciate her help. Okay, cool. So let's start with just an overview of what we're going to talk about. So basically, we're going to talk about types of work. What types of work do screenwriters write about? And I'll just generally touch on three general ones that screenwriters talk about or write about in their screenplays, and how each of them are very vastly different, and what to consider if you start to choose to write on a certain subject matter and how it affects how you write the script. Then the second topic is just a general overview of copyright and how to really generally protect your work. And we'll talk about that and we'll go through that. And then what is fair use and public domain? I know that a lot of you screenwriters out there and producers sometimes mix the subject matters or use one to defend another one. And so I will just give some more clarity on how that all works and how to maybe avoid some of the pitfalls in those assumptions. And last is really what it means to clear a script. When you guys write scripts or you're reviewing scripts, some of the subject matters that you talk about in your scripts can be, believe it or not, very expensive. And I will just touch on how to sometimes avoid those expensive pitfalls and or what to do if you have an expensive scene or something in the scene that you need and how to go about getting that properly authorized by whoever owns those particular elements in that scene. So let's start with types of work. And here I've put in the works that I've actually worked on. These are some of the movies that I've been lawyer to, the privilege of working on. And each of them are an example of the different types of works that you may see when you're either reading a script or some things you're thinking about when you're deciding to write a script. So we'll start with the most complicated one, which is based on a person's actual life story. And the one that I worked on, it was called JT Leroy. And this is a personal true event story about this woman, and she wrote a book about it and how her life kind of evolved and romance ensued. And so what we had to do here is, because it was based on somebody's real life story, us as producers needed to go to the person who actually the story is about and approach the person who wrote the book and not only get permission to say, we want to write a script about your story, but also get permission to use the book as reference materials to write the script. So here there was two levels of considerations that we needed to really look at when deciding how to go about getting the rights to write the story. So here, again, we had to do two deals. We had to do a deal for the book and a deal to get the permission of the person that the script is being written about. And that's called life rights. So we need to get a life rights, and we needed to also get the book that the person wrote about themselves. So those were two different negotiations. They were two different kind of sets of rights. And we needed all of those things so the screenwriter was able to use not only the source material of the book, but also be able to use the actual person that wrote the book or who the story is about as a resource in interviews and really getting their feedback as the person wrote the script. The next one, as far as complication, is, and I'm using here Chappaquiddick. For those of you who are old like me, there was in the 1960s a very famous incident that happened with Ted Kennedy and an unfortunate accident with somebody that he was in the car with that he had driven off a bridge and got into an accident. And unfortunately, the woman that was in the car with him had passed away. This is what we call true events or true historical story. So here, it's not based on anyone's life rights. It's based on this story about the accident and how the accident happened, using things like newspaper articles, interviews with the police who were at the scene, eyewitness testimonies, and of course, Ted Kennedy, who happened to be in the car, and his recollection of what happened. So here, what we needed to do was get rights to certain aspects of the true events that we needed to help write the script. So for example, if we had used an article written, say, in the New York Times, we needed to go to the New York Times and ask for permission to resource their material as part of writing the script for the whole incident of the Chappaquiddick script. We also potentially went to people who were there, who are still alive, who could talk about it. For example, the police department sheriff who was running the department at the time, and his recollection and his storylines. So here, we didn't necessarily have to really rely on one person and their recollection as the entire story for the whole script. Here, we can use different resources that we are able to resource from different avenues to get one story and one script. So that's another way you can really look at getting rights to a story and how you screenwriters out there can look at writing stories. Then the last one that I, again, had the privilege to work on is a movie called Greenland. And this is a post-apocalyptic story starring Gerard Butler. And this is what I would call the easiest story to write, or the easiest events to write about and to produce, because Greenland is based on a wholly original story. It is not based on anybody's true life or something that happened in history. This is an original story that came out of one person's brain. We did not need to get rights to a book. We didn't have to get rights to a person. A script was written, and we were able to then make sure that everything in the script was within the person's own original mindset, and then that is easily produced as a screenplay. So again, staying on high level kind of understanding, these are the types of works that you generally look at when you're going into writing a screenplay. Next, we will talk about copyright. Now, copyright is a whole topic in and of itself, and law school students spend 4 or 5 months just learning about this stuff. So I'm really going to try to tell you what it means and how it applies to what you would want to have happen in order to protect your work. Generally, there are 2 ways to protect your work. Well, really 3, but 2 formal ways to do it, and a third one, which is what we call common law or common understanding of a copyright. So here, if you see here, this is a picture of a screenplay, and it was registered at the WGA, if you could tell by my slide. But moving down, we can talk about the first, what I call formal way of registering or protecting your work once it's been written. Now, you can do it a very informal way, but it is papered through the Writers Guild of America. And there's Writers Guild of America East, and there's Writers Guild of America West. Depending on what side of the country you live on, you would go to their website, and there's a very easy way through their website to register with the WGA. It's useful because what it does is put on public record with a third-party foundation that you have put on notice to everybody that it's been registered. It's much faster than what you would do formally through the United States Copyright Office, which I'll talk about in a little while. And it's also much cheaper. You can file it for a very reasonable price, and the filing has an expiry date, as you can see from the slide. That is, I would say, a benefit because it's cheaper, but a disbenefit or a good way to miss out on additional registrations, because you have to put in your mind, oh, in 10 years or 5 years, I have to go back and re-register it or re-protect it. Another thing with the WGA, it's only written specimens only, so you wouldn't be able to register, say, your movie once it's made. It's only written specimens. But the good thing about the WGA, again, you can do it yourself. It's much cheaper. The form is very simple and easy to fill out. And the mechanism in doing it, at least you'll have something on paper, which is a certificate of registration, which you see here on the slide, that will show the whole world that you have put everybody on notice that you have registered your script. So this is the Writers Guild of America process. It's, again, very simple, but not necessarily the best solution, but I would call this the second best solution. Now let's talk about copyright. Copyright registration is federally protected material. Once you register with the copyright, you have the benefit of saying that anybody in the whole world can see your registration. They can file it, they can look up for it, and it's in the registry of the Copyright Office. Your registration is many, many years past your lifetime, and it can be renewed under certain circumstances. Also, it is the way that financiers and banks and distribution companies will be able to verify that you, in fact, are the owner of your script, because, again, it's on public record. Anybody can go and request this certificate and know that you are actually truthful in when you say that you own the screenplay. The downside to the copyright registration, currently, you can register it at any point, but it's now approximately 4 months as of this recording. During COVID, it was a year, but they are catching up to get your certificate. However, the date of your registration is actually the date that you can say and rely on to when you talk to third parties about when you are registering the script. Also, it's a bit more expensive depending on how many registrations and the type of your registration. It averages to be between about $65 and $125 per filing. So if you're writing 5 or 10 scripts in a year, that can get to be very expensive generally. Also, the filing process is a little complicated. You have to go through their online portal. You have to get approved to be on their online portal. And most of the time, I recommend that you hire an attorney to assist you with doing that, because if you do anything wrong in the filing, it takes a little longer to get it amended and refiled. And then it creates a little bit of confusion when the copyright is pulled as far as the record. Again, you can see here on the slide a picture of what a registration looks like. This is what you get in the mail once it gets through the 4-month process. So fair use and public domain. This is really fun and really complicated, but really cool to see that there are several different ways that you can have an inspiration in writing your script and not have to go back to what I had mentioned before, meaning the Chappaquiddick versus JT Leroy situations where you're going to ask for permission to use material or things that are based on your script at the current time. What fair use and public domain generally really do for you is give you kind of a break in the ability to use other people's work. And again, I'm not going to go into fair use and public domain in a whole lot of detail because, again, it's also a semester class in law school, or, the USC film students out there who are studying the business of film and production. But I can say that if you think really, really old, really old, like early 1900s or silent movies, those things are generally what's called public domain or works in public domain. And those are things that you can actually use without obtaining permission. So in my slide here, in this first slide, there is a Night of the Living Dead, which came out a long time ago. And say that you wanted to use some of the characters from Night of the Living Dead, or you wanted to inspire your storyline based on the main actor or character in that story. If you were doing that with modern times, like say using John Wick as your main character, we all know that you wouldn't be able to do that because John Wick is a current character and protected under copyright law. But here, for example, Night of the Living Dead, you want to use one of these characters, you wanted to use a similar storyline, you wanted to use something of note from that particular general storyline or project of that movie, this would be something that we would call public domain. And public domain really is meant to say, like, look, creator, you've had many, many, many years to be able to exploit your project, make money off of it, take all the accolades you can from it. But at some point, it needs to be given to the community. It needs to have a way to be able to say, you know what, let the rest of the community now use it and have it be inspiring other people's creative works. So it's a very misunderstood concept because people think just because it's in the public, meaning it's on the internet or it's been on the news or anything like that, that's what's public domain. That's in fact a misnomer. Really, public domain has to do with age, like the age of a wine, right? So it's been exploited so many times and basically all the juices have run out of it that like now it really needs to give back to the community. So that's kind of where we lie with a public domain. Another example here is Sherlock Holmes. Sherlock Holmes is a very old book written in the Middle Ages. And the character of Sherlock Holmes is, everybody knows him, everybody knows who he is. But now, since it's the Sherlock Holmes is now in public domain, there can be several different projects based on Sherlock Holmes, to which then the idea of Sherlock Holmes can be used by many different writers, authors, and filmmakers. So here, I've put a case here that you can read about, which has to do with the book, The Sherlock Holmes Study, and how potentially there was some issue about how the work was used from public domain versus the actual book, the current book was used, in that basically what happened is the book author had put their own sets of understanding of the Sherlock Holmes, and that is on its own arguably a new copyrightable work aside from the public domain of Sherlock Holmes. So what happens is, and that's why we put this poster here, is that to say like, okay, the Sherlock Holmes in this movie and the storyline about Sherlock Holmes is in its right, its own copyrightable work, because it is a derivation or a new work based on a public domain. So the public domain still remains the same. Anybody can make a movie on Sherlock Holmes, but the way that it was told here with Rachel McAdams and Robert Downey Jr. and this storyline, it has its own now new copyright and has its new protection. However, if I feel like I want to write a whole new Sherlock Holmes that has nothing to do with Robert Downey Jr. or a Jude Law character, I'm totally wholly available to argue that it's in public domain. Okay, so here again, we can talk now that the basics of copyright and public domain and copyright and fair use. So again, one more example of public domain. Here is Winnie the Pooh. Believe it or not, Winnie the Pooh is a book that was written in now what's called public domain. So, the characters or the way the storyline is, that can be arguably in public domain. But if I were to make a new character that looks like a bear that is named Winnie the Pooh, but the visual characterization is completely different, what I say is I get protection over my visualization of what I think Winnie the Pooh looks like now. But I cannot say that I own Winnie the Pooh anymore. And again, I know there probably will be a lot of questions about this because it's very the way that you look at it. That's why I wanted to show you the Sherlock Holmes situation where Sherlock Holmes, the storyline, and the man who was just a book about versus these books that were written in the 1920s that have the animated series here of what Winnie the Pooh looked like for that person. That visualization is in the public domain now. However, if I make my new bear and I totally change it and I get to name it Winnie the Pooh, it could be argued that although the name Winnie the Pooh I can't own, my visualization can't be used by anybody else. Okay, now public domain is what, if you think really, really old. Fair use, on the other hand, is something that the copyright law has carved out in very small amounts of permit, and where you have to be specific on what it is that you want to use. Now, fair use is you're using elements of a copyrighted work. There is a test that you can look at and say, well, I want to use, let's say, a Coke bottle in my shot. And I feel like I don't need to go back to the Coca-Cola company and ask them for permission to use their copyrighted Coca-Cola logo. Potentially using fair use. Again, I'm not saying that it's a hard and fast rule, but as an example, if you look at maybe the Coke can is not in the scene or it doesn't interfere with the main storyline of the whole script, and it's an ancillary or very minimal use. Sometimes you can try to argue what's called fair use. Fair use would be something like it's not, a pivotal need for me to have. Going back to the Coke can example, the Coke can, say, is in the corner on the back of a table and it's a little blurry and people are talking about how they're going to the pool. Well, using that example, we could potentially argue, hey, the Coke can is actually fair use because A, the scene is not about Coke. B, it's de minimis use, meaning it's in the background. C, we could say it's kind of blurry. Nobody really can tell it's a Coke can. And D, the entire script does not have or talk about Coke. So this could be something that we could say could be justifiable as a fair use of something that is currently protected. Now remember, public domain old, fair use new, and I need to get permission. So here, let me give some examples here. These are just really fun visualizations. Like if you see here in the Dexter shot here, just say I wanted to use this panel in my quick animated series about the military, right? If you notice here down at the right-hand corner, you see the FX logo. This is protected by FX. FX owns this. FX owns Dexter. FX owns these character animations. They own everything. So it would be something where I would ask if I was doing my animated series, do I really need this to be used? Number two, is it a long view of this particular visualization? Number three, can you absolutely tell that this is Dexter and this is his character. The one on the right, the Dexter example here, I would say and recommend that you would either take it out or we go to FX and try to get it approved. The Homer Simpson here, same thing. When you're looking at how to do these different clearances, again, this is clearly and visually a Homer Simpson's visualization. This is something, again, that I recommend that we get approval on, and that we would not be able to really try to argue fair use. And again, fair use is a very limited exception. I always recommend when my clients call me about, hey, I have a magazine in a scene and I would like to ask the magazine to give me approval, or can we ask for fair use? I always recommend that for several different reasons, one of which is your mental stability and clarity, that we just go ahead and try to clear it. So what we usually do with those situations is we call the publisher, we ask for permission. Most of the time, the publishers will want to know what issue it is, page we're showing, and why we need it in the scene. In other words, again, for an example, we cleared a Playboy magazine issue one time, and Playboy needed to know who was in the shot, what the article was about, and they wanted to read the script, especially with knowing what the scene is that the particular use was going to be. So some are very easy. For example, if you want to do and show a Skype call in your scene, Skype and those guys over there are very amenable. They actually have a form that you go on and you just download it, and you're able to obtain permission very easy. So I think, and let me just give you one other example of fair use. I've worked on a documentary, and part of that documentary had a lot of clips of the Sunset Strip that were filmed in the 1950s, and they were showing a progression of what the strip looked like from the 1950s to current. And they would show things like the outside of different restaurants and cars and different things like that. And in that situation, because they were clips, very quick clips, and they were about a subject matter that had to do with newsworthy events, and it was a documentary, we were able to argue that a lot of those clips were in fair use because, again, the subject matter was not about any particular car that was in the scene or any particular establishment that was being portrayed, but to the fact that it was based on a newsworthy event and it was in a documentary, non-fictional mode, we were able to go ahead and get that under the fair use argument. Okay, so the next thing is clearing a script. I think this is the biggest topic because it's really about how do I write a script legally? And I know that's a weird concept because no screenplay writer wants me to tell them that they need to write their script legally, because when they're writing scripts, they're not thinking about legal application. They're thinking about storylines and arcs and drama and those types of things. But it would be helpful if you really kind of understood what is a script clearance and what it means to clear a script. So basically, I say when you clear a script, you're looking at the script not from a creative point of view, you are looking at it from a legal point of view. So I always make a joke when I read a script, I don't enjoy it because I need to look out for all of the pitfalls and things that could potentially lead a screenwriter to legal trouble, things that I find that would be flagged that could either we will not be able to insure the production, or things like too expensive. I have a super yacht in the script and I need to shoot a super yacht. So we will start with things like, which are number one flags when you look at problematic things when reading the script from a legal point of view. Things like copyright infringement. Again, going back to the Coke example, if you're saying in a scene that there's a Coke can in the scene, are we looking for issues like, do we need permission from Coke? Another thing is, and similarly related, is trademark infringement. If you have somebody wearing an Adidas shirt in the scene and has the Adidas logo on it, is that going to require us to really go back to Adidas and get permission for that particular person in that scene to really need to wear that outfit with the Adidas logo on it? Also, if there are real people in the script that you're talking about, we have concerns about, are you defaming them? Are you talking about untruths? Can we show from our research that some of the things, although not to the best light of that character, may be fair and in a person's ability to prove prove that that's what had happened or the occasion was within the person's understanding of the true life events. Also to the invasion of privacy. Are we writing about something that somebody feels like they had not given permission to talk about? These are things like, again, as an example, intimacy stories or criminal behaviors that may have been expunged later in a person's life, things like that. Right of publicity. Right of publicity is things that are protected from people in the public eye. So if you would do a story about Hillary Clinton and giving Hillary Clinton an eye of things that are not true, there are things that's called right of publicity, which helps protect people in the public eye from not being ridiculed, especially if they're untruths. And then story rights issues. Story rights meaning, again, going back to, are we telling a story about a true life person, or are we wholly original and nothing in the script is about anybody? So what the best thing to do when you're thinking as you're writing the script is to really not, I would say, stay neutral to things that you cannot either prove, or when writing scripts about real life events or true life people, or things that you can have backup for. Again, news articles, books, people's assessments of their viewpoint on what happened in that particular occasion. These are all things that as you're writing the script, you could keep in your mind from a legal point of view, like, well, I shouldn't say that that person wanted to jump off a bridge and kill themselves if I can't really, about a real person, I can't really have proof that that happened. So again, a lot of these script clearance issues goes back to the first slide I talked about, which is what basis of fact are you using for your script? Original, wholly based on everything only out of your brain, up until the two other examples that I gave earlier. So as you write, I would recommend, and I always do to my screenwriters, try not to be specific unless absolutely have to. Don't write, they went to Dunkin' Donut, right? They went to a donut shop. So we can keep it more general. And I don't have to go to Dunkin' Donuts and ask for their permission to film in their store because I need to show their logo because my screenwriter absolutely has to have Dunkin' Donuts in their shot. Another example, again, is things on clothes, logos on clothes. That's why you notice when you watch a lot of television or reality television, many of the people wear white t-shirts or very plain clothing without any logos on, because you don't want to run into a logo being on somebody's shirt and you see them then acting in a non-moral way, let's just say, and the owners of that trademark really get on you because you have them in their own logos doing bad acts, which then devalues their logos and their business. So again, if one other example, which I've had to deal with, everybody's drinking coffee and you've got the Starbucks logo on your coffee. Depending on what they're doing when they're drinking coffee, they're not doing anything. Maybe Starbucks won't care and will give you approval. But if they're drinking coffee and they're robbing a bank, then we're going to have a problem with Starbucks saying, yeah, I don't really want my logo in a scene where somebody's robbing a bank, right? So that's just some really great feedback on what to think about as you're writing the script. What we do here when we do production legal, once a script is written, we pull what's called a clearance report, and a company actually goes through each and every line of your script and comes back with a report on potential legal issues. Usually, depending on how long your script is, the report is almost as long as your script. So it could be anywhere from 90 to 120 pages. And they go through names, they go through what products are being used, street names, different logos, things like, if you're in the store, they flag like, just make sure that the store is a prop store and you're not using names like Vons or Ralph's or Albertsons in your shot. I did a movie called Breaking News in Yuba County, and Allison Janney was in a scene where she was in the store and she kind of had jokingly kind of dug on how bad the cake was that that store had made. So when we got permission to film in that store, they were very careful with us about making sure we covered up anything that was store related and the name of the store, because they didn't want to think that they were making bad cakes. And I know that sounds very specific and detailed, but we deal with this every day. So the better that you can, as you write your script, think about those issues as you're writing. It gives us much more tools to be able to get a better clearance report from the company. company. And the ones that are flagged, we can easily try to pinpoint a solution to them or decide to write something else. So for example, going back to the Coke can example again, I would say, hey, you know what? I can't get clearance from the Coke can as I'm reading your script. Do you think you could write about a different product? Let's see if we can get Pepsi to approve instead. So it gives us a lot of pre-planning before we shoot the script, and it allows us to flag many different potential legal issues that are contained in the script that sometimes maybe the screenwriter had not thought about, or things that we really need to clarify and make sure that things are in line with legal principles and everybody's comfortable in shooting the script. And we try to avoid as many, I guess, pitfalls within the script as possible. This, of course, is always challenging too, because when we get to shooting the script, then you get to start the process all over again. And I'll just make a quick note of that. Again, it's not a topic, but it's called movie clearing. And movie clearing is once we actually have the shot ready and we're ready to film it. And I can give a great example because these posters behind me as we're shooting this webinar, the question is, again, as another layer of movie clearance, in the scene, it just says movie posters on the wall, right? So we don't know when I clear a script, which movie posters are actually going to be in the script. It would just be flagged like, make sure that the movie posters that are in the scene are cleared. So when the production designer goes ahead and puts my movie posters up in the scene, first question is are these movie posters cleared? Do we have approval from, I think this was Warner Brothers, this movie poster? Do we have permission to use this movie poster in the background here from Warner Brothers, or do we need to replace it? So as you can see, it's a layering issue and a constant purview and monitoring of how things are cleared and what stages they're cleared at. Okay, so my fun part. I am ready for questions.
Thank you so much for your presentation, Tifanie, and sharing information with us about avoiding infringement. It was great. I'm going to go ahead and start with the first question. I would like to know about using political figures in my plays, as well as known Mexican-American activists in the 1960s. I would like to use their real names. These individuals are no longer alive. This work can also be made into a screenplay.
Okay, so in general, public figures are what's called, they have less protection than private citizens. So if you notice, there's a lot of movies about Madonna, Whitney Houston. These are people in the public eye, and they have less expectation of privacy than people in the private sector. So with regard to your Mexican-American activists in the 1960s, I think this would be more, again, depending on if you're just doing it about this one person or about a particular event. In the 1960s that this American activist participated in, you would be in the two buckets of either, is there this activist, are you writing the script based on something that is out there about that person? So if you saw a book that was written about this person and you wanted to use that book, you would need to go and get permission from that book author to use that material as inspiration for your screenplay. So although the answer is generally yes, you can use real names, it gets a little bit more complicated than that, in that, yes, you can use real names, you can tell the story. The question is what material are you basing it on? And how much material do you need to get permission from the reference material that you're using for that particular person?
That's great. Thank you, Tifanie. I'm going to go ahead and move on to the next question. What type of deal and advice would you give to writing and hiring talent that is playing themselves in a fictional piece? For example, LeBron James in Trainwreck.
So I always say real people in fictional circumstances is a character. This person is just a character. Just because they're playing themselves doesn't mean that you're telling their story. It's very different. So in Trainwreck, he just happens to be, LeBron, right? But the movie is not about LeBron. It's about the fictional aspects around that. So what I would say is if you were writing with somebody in mind to play that character, like I need Nicolas Cage in this movie because it's about him being an old celebrity that's not really working in the motion picture industry anymore. And he's perfect. And I'm writing him in mind for this character. It's still a character because the story is fictional around him. So I would say the deal would be just to straight talent deal and permission to use the name of the celebrity within the script as the character name. Now, if you were using LeBron James and a different actor, that's when we get back to the earlier discussion about clearing the script, and the script clearance company would flag LeBron James. You should not use LeBron James as this character because we all know who LeBron James is. You should either make the character's name much more common, like Dave Jones, versus a LeBron James, unless you have, again, a really particular need to have LeBron James in the movie, then you make the deals for him as being in the movie and permission to use his name.
Okay, great. We have another question. What type of deal and advice would you have for hiring writers, consultants, for expanding creative development without bringing them on as a co-writer?
Okay, so when you're collaborating for your screenplay, what I suggest, there's a couple of different ways to do it. There's collaboration, which everybody contributes to the work and owns the work collectively. There are ways where you hire and pay people to help you write the script, but ultimately you will own the script 100%. And then what I call the hybrid deal, which is everybody was just writing the script together, or a screenwriter was writing it, but maybe it called a couple of friends, or one night they were all sitting around and everybody kind of helped out. Collaboration in the creative process is always very open and freeing, but when you look down to it and actually get it down on paper, you really have to look at what everybody's expectation is with regard to what to do with that property. I've had many occasions where people have written scripts and have said that they've wholly written it, that they're a Greenland situation, that it's all from me, it's only from one screenwriter, and I did it. And later on down the road, we find out that, oh, wait, no, my friend, he wrote scene 3, but he's my friend. He knows that it's my script. Well, friendship sometimes ends real quick when somebody doesn't have an expectation or does have an expectation of what they are involved in the script going forward. Maybe that friend really had an expectation that they would get credited because they did help. So it's our job, once we really look at a script or we look at collaborations, to really get from the people who are involved in it what the expectation is. So I think as a super conservative recommendation and things that are clean, that if you really truly are and want to be the only person that is attributable to that script, that you pay and you have a contract with each person that you hire to help you with that project that specifically states as part of the agreement that anything that they do for you and you pay them for, that they have no rights on, that everything is assigned to you as the person who paid them to do the work.
That was a great question. Okay, I'm going to go ahead and read the next one. If a film is stated to be fictional but based on true events, do I still have to get life rights?
No, in general, no. The thing that becomes fuzzy here is that the reason why it says fictional but based on true events is that the authors or the screenplay writers or the producers have taken a fictional viewpoint on a true event. So an example would be Quentin Tarantino's movie where the end, they actually kill Hitler at the end, in a big firestorm, right? So it's a true event because it's based on World War II and the war efforts during that time, but it's also fictional because we all know Hitler wasn't killed in a blaze of fire in a theater. So I would say that you would just really have to look at what is fictional in comparison to the true events, and if one outbalances the other, and depending again on what resource materials you're using to write the script, it could be definitely more on the fictional side versus the true events / permission side.
Here's another question. If a story contains more than one real person's life, do I need to secure life rights for all of the characters, or would only the main character's life rights be enough since the other characters are part of their life?
Great question. I worked on a little bit of this movie called The Dirt. It's about Motley Crue. And that's, I guess, an example that I could use here that, if only going to get Vince Neil's the lead singer of Motley Crue's life rights would not be enough, because the story is about the band and about all of their kind of interactions with them up and coming through their success as a rock band. So again, it would depend on how much source you need. But if you're telling the story about Vince Neil and only Vince Neil, you could potentially argue that the other characters are ancillary and that you are not using them as a source material. But most of the time, if it's about a group or the real person's life has substantially do with a group of others around them, like, for example, like a SEAL Team 6 idea, you try to get everybody who was at that event, that particular event, to give your rights. It becomes much more easier to say to a studio or a financier, hey, not only do I have Vince Neil's permission, but I got the whole band. It creates much more of a comfort for these financiers and distributors to know that, like, you're telling the story of the band, and somebody else who wants to tell the story of the band is going to be very hard pressed to get such rights because you've already got the rights. So it's a question of leverage and kind of carving out your own ability to tell a story and not have anybody else tread on your own material.
Okay, great. We have another question. Any advice for younger attorneys 1 to 5 years out of law school to break into IP entertainment law in addition to attending this CLE?
Yeah, our industry is very small, but I can tell you kind of a little bit how I got into it, and some of my other people who have worked with me have broken into it, but you really have to start at the bottom. I mean, I know there's a joke that, like, you have to start in the mailroom to get anywhere in the industry, but it's really kind of true. It's a very unique and eclectic specialization, and there's a lot of nomenclature in our business. We use a lot of short-term acronyms all the time, and if you have to get educated and understand those types of things. So, start in the mailroom, start on as a receptionist, start as a law clerk, start small, but learn and be available and work twice as hard as you would even as an attorney, really, to be honest with you, because part of the thing that I always tell my students when I help teach one of my friends' classes every semester at USC is that, you have to persevere, because this industry is very competitive, but you have to get into the right circles to get access to the specialization that you want to be in. So IP and entertainment law is huge. It's anywhere from things that I do, production legal and talent rep, to being a music lawyer or being in litigation or being a straight trademark attorney that all you do is file trademarks for your clients and their logos and their brands and their mascots and all that stuff, all the way to publishing, like book publishing. I mean, it's a huge industry. So you really have to find passion in what you do. I mean, I've had law clerks work for me and say, I don't know how you do independent production, because it's always a very hard set of circumstances, and there's always so many moving pieces that I just can't keep up. And to somebody who was like, you know what, I just love litigation and I just want to argue all day, and I don't care about script clearing, or I don't care about what it means to copyright anything. I want to figure out how to get people in trouble and sue them for it. So, there are different internship programs. I would say look at the smaller boutique and individual attorneys. They're probably more apt to getting back to you and not have as many hurdles to jump over as far as applications. And definitely take your ego out of it. If you're a lawyer and you need to take an assistant job, I had a law clerk who was my law clerk many years ago. He got on the desk at the business affairs at one of the agencies as an assistant, and now he's actually moved into working in that department as a lawyer. So that's what I would say for that.
That was a great question. Do you have any advice to approaching or reaching out to companies or individuals in a project to avoid infringement?
Many of the big companies actually have things on their website that say, like, grant permission or clearance issues or things like that. A lot of the book publishers are very well understanding when you call the publisher and say, hey, I need a book, or I'd like to talk to the author about using their book. They're very good at supporting that, because that just means that if their book becomes a huge multi-million-dollar motion picture, that's just great advertisements for the publisher. Also, I've found that the grassroots research on social media, getting hold of if you need, say, for example, to use some weird jewelry that's owned by somebody that lives in India. Sometimes it's easier to get a hold of them through social media and just get their permissions that way. It doesn't have to be necessarily formal. It's more about the fact that you have acknowledgement and something in writing that gives you the permission to use it in your script. Obviously, when you get more bigger budgeted scripts and bigger things, then things become more complicated and we have to get insurance and get a bond that makes sure everything is in line and legal. So, but with the projects as you build with them, I think if you keep in your mind, like, let me try to find this person. If I can't find them and I can't use this jewelry, let me figure out somebody else. Or let me make my own jewelry and I put it in the scene and I don't need to get permission, right? So you have to think creatively and things that may you come running into, figure out solutions to get around them, but you still get the point of the story.
That's great and makes so much sense, creating different alternatives. Okay, here's another question. Do you have advice to creating script clearing reports?
Yes, there's, if you Google script clearance companies, there's a bunch of them out there, and different people have different needs for clearance. You could do a full clearance where a company actually does the clearance for you. So they flag the Coke can, and their services also include calling Coke and getting that cleared for you. So depending on your budget and how much you need that Coke can in the scene, they can do anything from just flagging the issue to you to all the way to getting it all cleared for you. So it's about budget. Script clearance reports are not cheap. I think the last time we ran one was a few months ago and it was $1,500, but it is very well worth your money to spend because you can definitely see things that are flagged in your script and assist you in either, again, changing them and making them non-issues anymore, or figuring out a way, well, like I need to call Playboy or I need to call Wall Street Journal because I really need this in my scene. So
great. That was all the questions for tonight. Thank you so much, Tifanie, for your presentation.